Good morning, everyone. I am Great Siren Q de la Peña from BSc 3-4, and I am here to discuss with you the domestic arbitration. So, first, let us know the objectives of this report. So, at the end of the discussion, the students should learn and define domestic arbitration. 2. Demonstrate the due process in domestic arbitration. 3. Know the procedure for appointing the arbitration and the procedure if he fails to enact. And lastly is explain the rules on receipt of written communications. So first, what is domestic arbitration? So arbitration is domestic if the components of parties, place of business, place of arbitration, place of performance of substantial part of the obligation, and place where the subject matter of the dispute is most closely connected are all located in the Republic. So, meaning to say, arbitration occurs between two parties who are citizens of a country where the arbitration is performed. Next is due process in domestic arbitration. The parties to a domestic arbitration, like in the case of international commercial arbitration, are entitled to be treated equally with due process. So, in due process, in case of involving domestic arbitral proceedings, the Supreme Court held that the well settled rule is that administrative agencies exercising quasi judicial power shall not be confined with the rigid technicalities or a point of law or small detail or set of rules procedure. Although there are procedures that need to be implemented at all times. So to adhere the basic concept of fair play, it means the main focus is to respect equal treatment of all people concerned. Submission of position papers may be sufficient as long as the parties are given the opportunity to be heard. So if we say position paper, we are referring to arguable opinion of an issue, and it is used to explain the opinion presented is valid and worth listening to. So, in administrative proceedings, the essence of due process is simply an opportunity to seek for reconsideration for a review of the action or ruling complained of. This constitutional mandate is deemed satisfied if a person is granted an opportunity to seek reconsideration of or review of an action of ruling. So take note that it does not require trial type of proceeding, but it is similar to those in court of justice. And also, the place of domestic arbitration is to be determined by the parties. If there is no such agreement, then the arbitration shall be conducted in Metro Manila, unless the arbitral tribunal shall different place taking into account the consequences or circumstances of the case and convenience of the party or practice. Next, rules on receipt of written communication. So, the general rule on receipt of communication in international commercial arbitration as well as domestic arbitration is that provided for by the parties in their arbitration agreement. In the absence of such agreement, written communication among the parties and the arbitrators shall be delivered personally by registered mail or courier service shall be deemed to be received on the date it is delivered at the address of record, place of business, and resident or last known address. So, okay, next, the use of electric mail pass. Next, the use of electric mail fast mail transmission or other electric means is permitted, as long as there is a record of the sending and receipt of communication at the recipient's mailbox, and such electronic communication shall be deemed to have been received on the same date of its transmittal. Next, commencement of arbitral proceeding. In general, the start of arbitral proceeding is determined by the prior arbitration agreement between the parties, up to the extent there are similarities between international commercial arbitration and domestic arbitration on the commencement of arbitral proceedings. So, the following are the specific rules on the commencement of domestic arbitration. So, in institutional arbitration, where there is no prior arbitration agreement, it is commenced in accordance with the arbitration rules of institutional arbitrator. Second, in ad hoc arbitration, where there is prior arbitration agreement, it is commenced upon the delivery by the claimant to respondent of a demand for arbitration. The demand for arbitration shall be in any form and shall state the name, addresses, and description of the nature of and circumstances of the dispute giving rise to the claim. The relief suit, including the amount of the claim, the relevant agreement, including the arbitration agreement, and a copy of which shall be attached where there is no prior agreement. It is initiated by one party through a demand upon the other submit their dispute. Arbitration is deemed commands upon agreement by other party to submit the dispute to arbitration. The demand shall also require the respondent to name his arbitrator within a period which shall not less than 15 days from the receipt of demand. The default rule in the case of international commercial arbitration is that it is commenced on the date on which a request for the dispute to be referred to arbitration is received by the respondent, while for domestic arbitration, where there is no prior agreement in recon from the date where other party agreed to submit the dispute to arbitration. Next, the procedure for the appointment of arbitrators. So, appointment by the parties. In arbitration with three arbitrators, each party shall appoint one, and the two arbitrators shall appoint the third arbitrator within 30 days from receipt of request. Failing of which, the appointment shall be made by the appointing authority. Second, default appointment by appointing authority. A default appointment time to make the appointment shall be made by the appointing authority. Third, request for appointment. Within 7 days from the receipt of request, the adverse party may file his objection to request or ask for an extension not exceeding 30 days to appoint an arbitrator. Fourth, acceptance of appointment. If he agrees to comply with the applicable law and rules of the tribunal. The tribunal shall render its written award within 30 days after the closing of the hearing submission of the parties brief. 7, 8. From form and content of the award. It shall be in writing signed by the arbitrator initially state the rendition and place of arbitration. The award did not be acknowledging or sworn to unless required by the parties. The parties may require the tribunal to support the omission within 30 days from receipt of the award. Last, termination of the claim. The proceeding will be terminated by execution of an arbitral award on agreement terms unless the respondent objects for the purpose of prosecuting his counterclaims or the tribunal recognizes a legitimate interest on his part in obtaining a final settlement of disputes. Next, procedure in the case the arbitration fails to act. As in the case of international commercial arbitrator, if an arbitrator in a domestic arbitration becomes the jure or de facto, so the jure or de facto means by law or right to perform or unable to perform his function or fails to act without undue delay, his mandate terminates if first withdraw or the parties agree on the termination in the controversy remains, any party may request the appointing authority to decide on the termination of the arbitrator, which decision shall be immediately executory and shall not be subjected to appeal. So, confirmation of domestic arbitral awards. So, recognition of domestic arbitral awards is made by filing a motion for confirmation and securing an entry of judgment from the court. An award in domestic arbitration is rendered by a Philippine Arbitral Tribunal applying to Republic law. So, all that is required in order to enforce domestic award is to have it confirmed though through a motion filed in court. Similar to international commercial arbitration, proceeding for recognition and enforcement application or setting aside an award and any application for arbitration except appeal shall be deemed as a special proceeding. So, in conclusion, due to its many benefits over traditional legal proceedings, domestic arbitration has become the most common method for resolving conflicts in variety of areas. So, generally speaking, arbitration moves along faster than court's action, which is frequently held down in backlogs and administrative delays. Due to faster procedure, disagreement can be resolved more quickly, reducing the impact they can have on both personal and professional life. The effectiveness of conflict resolution can be significantly increased by having a well-defined schedule for procedures. Domestic arbitration can also be less expensive than traditional litigation. Even though legal bills might still mount up, arbitration frequently has cheaper total expenses because of its streamlined process and shorter time constraints. So, recommendation arbitration awards are typically final in binding with very few grounds for challenging a decision. This finality can be problematic for practice or parties who feels that an award was unjust or based on error, leaving them with little recourse for a correction. By expanding appeal option, ensuring impartiality, controlling costs, implementing procedural safeguards, promoting consistency, increasing transparency, addressing enforcement issues, and balancing power dynamics, the arbitration process can become a more equitable and reliable means of dispute resolution. So here are the references. And Arbitration is justice blended with justice. So, this is the end of my report about the domestic arbitration. Thank you.